a matter to come up for order on Wednesday.
Urgency is there. Wednesday means tomorrow.
No.
Next Wednesday.
Next week.
Which year matter? Which year?
It's a 22 matter and it was last listed on January, my lord. 2 weeks time was taken. Like,
I'm paying for listing of two motion matters. Courtesy permit tomorrow. Like,
may please, if I expect to mention item number 4.
Yes.
First, may I kindly attend the matter today as Mr. C. Guru is unwell.
Okay. 17 matter, since he's unwell, will accommodate otherwise.
May fix it.
we
The
have
last
no objection, man.
Hmm?
And for petitioner. We have no objection there in.
When?
July last or August.
No, not July last. Will be
Okay,
under reopening.
Yes.
It's a 17 matter. A prayer for adjournment has been made on behalf of Sri C. Barua, Learned Council, for the
NHL, respond number 6.
okay, C. Barua for Standing Council, NHAI. Para? On personal, on as he is unwell, as he stated to be unwell. Para? Considering the above, matter is adjourned to be listed on 16th of July.
First, may I kindly July last. He's on bed rest. That's he won't be, I think,
Okay,
able to
on 28th of July, 28.
oblige. sir.
28 July, 28/7. No?
I'm back to mention item number, my lord. 5, my lord.
Right,
Taken
yes.
on Friday, my lord.
Okay, all matter, okay, Friday. On a request made on behalf of the petitioner, matter is adjourned to be listed on Friday.
Oblige, your lords.
Item 12, appeals.
This is regarding that Hubli matter. It is not correct that notice was not issued, or it was issued on 13 and giving them in 7 days time to vacate. So 7 days time is up to 28.
Yes, Mr. Talwalkar.
My lord,
Notice is there.
my lord, I am over confirmed that is incorrect.
Huh?
I am confirmed that it is incorrect, my lord. Let them to file with the details, with the proof, my lord.
No, the notice, if it is there,
My lord.
and how many days have been given?
7 days time.
7 days, expiring when?
28.
Today is what?
Today is 17. Another 3 days earlier.
17.
No,
So we'll file the affidavit tomorrow.
Oh, let them file.
file affidavit, my lord.
Till
File a short affidavit.
I'll file this, whatever we have received. And on top of that, he applied for settlement last year. In the LSC, it was rejected because it is within 25 meters from the river. So in that area, no land can be settled to anybody.
Where is the notice, Mr. Sekya?
Yes,
In this one?
third page. Yes, in the SM, it is in vernacular.
Okay.
It is there, Lord. The third page.
Yes, what is your name? Mr.
My lord,
Talwalkar?
My lord, Sakir Ali, my lord.
Sakir Ali has been issued notice on 13/6 by the circle officer. Topsil is also there.
So I can give a copy of this right now to him also. Even now, this notice is still valid.
My lord, let the affidavit in details may be filed, my lord. I'll concur, my lord. Because I'm
No, why?
I'm overseer. It is not.
No, Mr. Talwalkar,
My lord.
your overseer will not do. But why should we disbelieve the AG who has produced the records?
My lord,
This-
my lord.
Okay, well, okay.
By tomorrow, we'll file it.
Okay,
No
okay,
problem.
okay.
Let the matter come up day after tomorrow.
after tomorrow,
Or
okay.
Friday, whenever it is convenient.
Friday.
On Friday.
You otherwise have time till 20th.
My lord,
Till 20th, you have the time to vacate.
my lord.
We
Yeah.
can have it on Friday?
Yes.
Okay. Heard Sri A.K. Talwalkar, Learned Counsel for the petitioners, as well as Sri D. Sekya, Learned Advocate General, assisted by Sri D. Nath, the Learned
I like that.
Senior Government
Friday,
Advocate.
no?
Para? When this matter was taken up yesterday as unlisted motion on the plea taken by the petitioner that no notice was issued for eviction, the matter was adjourned to be fixed today with a further order of maintaining status quo. Para? Sri Sekya, the Learned AG, has however submitted that instructions have been received as per which notice was issued on 13/6/2025 under the appropriate provision of law with a schedule the schedule whereby the land has been specifically mentioned. Para. The copy of the notice is also placed before this court. Full stop. Though this court is prima facie satisfied with such issuance of notice, comma, Sri Talukdar, the learned counsel for the petitioners, has again submitted that no such notice was issued. Para. In that view of the matter, let an affidavit be filed on behalf of the state. Full stop. Since, as per the notice, 7 days' time was granted to vacate the land, which is expiring on 20. Let this matter be listed on 19th.
So, my lord, a small prayer, my lord. I may be allowed to file the counter immediately thereafter, my lord.
That
So
will not know.
My lord, because
That will, you'll be at a you'll have the right, but it depends what would be the outcome.
my lord, that's why I'm not take time, my lord. Let me on Monday, I'll file in the meeting. Within it, I'll fight. I will not take time from your lordship.
That is why we have filed the day after tomorrow. Day after tomorrow,
Highly open.
19th. I didn't want him to.
No, no. But we have received the affidavit filed by the Milord Department, Milord. So we have to file our rejoinder.
Okay, what is the matter?
Matter regarding Milord,
Some lands were allotted to couple staff, Uchi couple,
Okay,
and they are, my lord, occupying part of that land. We have issued eviction notice.
they are protected by interim order.
yes,
Why are you occupying Koborstan's
no,
land?
Milord. Fact is that Milord, kindly press Milord, annexure 4, Milord, page 34, Milord.
Okay, you file rejoinder, but
Yes,
we'll
sir.
not grant you much time. How many? 2 weeks.
Yes.
We'll have it immediately on the reopening.
Fine.
Fair.
In
And
the
Milord-
second case, my lord, we are yet to file it, it will be filed.
Within that time,
Fine.
okay. While affidavit in opposition has been filed by the state in WPC 5084/2024, such affidavit is yet to be filed in the second case 5044 of 24. Para. Sri B.J. Talukdar, learned senior counsel appearing for the state, assisted by Sri P.K. Medhi, submits that affidavit would also be filed in the second case. Para. Sri Sinha,
Yes.
learned counsel for the petitioner, submits that rejoinder affidavit would be filed in WPC 5084 of 2024. Para. List after 2 weeks for exchange of pleadings.
Milord, another submission, Milord, kindly press Milord, order dated 4/10/2024, Milord.
Mm,
Is a explicit direction to file affidavit to the private respondent, Milord, but they did not file it.
Yes.
Because
Within the same time, the
our
private
case is-
respondent
Our case is based on the
represented by Sri G. Alam may also file affidavit.
interim order may continue.
Interim order passed earlier to continue till the next date of listing.
Oblige.
Item number 2, I am preparing.
Okay. Haldar?
Yes.
B. Haldar. Don't know. Present. B. Haldar is present for the petitioner in 5044 of 24.
Interim order person.
Interim order, there is one order only. I didn't really.
If it is task for inspection, lord, we have not received this.
আগৰ ফালে অকমান হেৰি দিলে হ'ল। নাই দিয়া। অলপমান আৰু উঠাই দিয়া।
It's the issue.
আৰু বছ হ'ব বঢ়িয়া।
Lord,
Yeah.
I pay for some time to send this, I not received.
Mr. Kotoki is very happy to give to concede to the prayer. Why? Stay order is there.
No, I'm,
Perhaps stay order would be there.
no,
No stay order.
no, Theodore, no, indeed.
Still you are happy.
I'm happy because I want the instruction from them. Later.
Okay, heard Sri S. Kotoki, learned counsel for the petitioner. There are also heard Sri S.S. Royce, learned state counsel. Full stop. Notice was issued on 16/5/2025 in this matter. Para? 3. Roy, the London State Council. Have you got the instructions?
Not specific.
Uh,
That's why.
Praise for, and is granted 4 weeks' time to obtain the instructions. Let's file a in opposition.
Obliged.
Item 6 and 7. 6 and 7 Mizoram matter.
Yes.
It should go back there.
Petitioner council is there.
Hmm? No, you should, this matter, why should it remain here? Why was it moved here?
Earlier, that was in Idol, then that was transferred also.
Transferred?
Yes.
For some reason or what?
Yes, also because the sitting judges perhaps they could not take up the matter.
Now perhaps there is no problem.
Their presence. Otherwise, I have no problem.
That impediment is not there now.
Perhaps.
You catch hold of, maybe it,
Yes, after some time, also, I'll
anyone connected, associated with Mr. K. N. Chaudhary?
after some time.
After some time, we'll send it back.
Yes.
Mizoram does not have any work. Why should we again? Yes. What are these matters?
My lord, this matter pertains to, my lord, constitution of the Boruland Territorial Council for the last 5, my lord. The election is coming on for the fresh term, my lord. So, my lord,
What is there to press now?
nothing, my lord, but even then, my lord, I am waiting for an instruction whether they are like to. May
No,
not
even,
like-
even if you are liking or disliking will not make any difference. This will be
That
an
is correct, my lord.
academic interest.
No, my lord, for the academic, I will not press, my
No,
lord.
no,
to
we are closing this.
spend
Part 3 A.R.
My lord,
Bhuya.
may I pray, my lord, one date for the instruction as the clients are, my lord.
20 matter in 2025, we are not going to. 5 years
Then we
term.
have to wait for the material instructions also.
No, my
If
lord,
that
that
is
is
the case,
only,
lordship,
only
may be
one chance,
possible.
only one chance, my lord, with all utmost respect. Not
Only for the
mat-
material
not
instruction.
material, my lord, but I want a written instruction.
The
not
AG has
press.
said something for which the court is also influenced. We don't like to deprive some council
My lord,
of material instruction.
my lord.
When? When are you expecting the instructions?
Next week, my lord, next Thursday, my lord.
Are you sure?
My lord.
Next Monday.
My lord.
Heard 3 A.R. Bhuya Learned Council for the petitioner. Also heard 3. The private respondent is number 1. Why?
My lord. my
also
lord
have
is
three.
appearing.
Saikya. Huh? Also heard Sri D. Saikya, the learned AG for the state, as well as Sri S.R. Rabha, learned counsel for the private respondents. Para? The matter pertains to the constitution of the BTC Council, which was in the year 2020.
My lord.
Full stop. The term of the council is 5 years, which is on the verge of expiry, and elections are likely to be held in September, likely to be held in September 2020 of this year. Para? Bhuya, the learned council has, however, submitted that he would like to have some instructions
Right.
with regard to the future course of action.
Right.
Para? Considering the above, matter is adjourned to be listed on Monday next.
My lord. Highly obliged.
Good night.
Please, your lordship. This petition has been filed.
Other
There is-
side, who is for the other side?
Senior advocate Mr. Datta was there.
S. Datta. Where is Mr. S. Datta? Try to locate Mr. S. Datta. Yes, Mr. Gautam. Your matter, we are sending back to the Mizoram.
Lordship, this matter needs to be heard.
Why?
Reason being, Lordship, two of the councillors who earlier represented this party's Lordship are both from Mizoram, your Lordship. The reason that what the matter is here, your Lordship.
No, some bench was having some difficulty in taking up.
Lordship, two judges are from Mizoram, your Lordship. Were earlier councillors in this matter, Lordship. That is what this matter was saying.
Presently even.
Presently, Lord.
Who's there?
Lordship, Honorable Mr. Justice Michael Tosan Kumar and Honorable Mr. Justice Nelson Taylor.
No, it will be taken up on a single bench matter. Some other judge will take up.
All right, Lordship can fix this matter on 15-7, Lordship. Let me complete my instructions in this.
No, but we don't like to burden ourselves. If there's a predicament for both the judges, but we have judges from outside, somebody will take up there. There are hardly any cases in Mizoram,
Lord.
If you go there,
Lordship will grant me opportunity on 15-7, Lordship. I'll come with a concrete.
not 15-7, you take time, we are going to do. No, there's extending instructions to send it back to these are permanent benches, they have to be given work. Why should we otherwise?
Next week, Lord.
Friday. Heard. Sri N. Gautam,
Lord.
learned counsel for the petitioner. Also heard Ms. P. Bhattacharya, learned EEG, Mizoram. Para? This matter, which pertains to the state of Mizoram, was transferred to this court as there were certain predicaments of some bench to take up this matter. First up, however, it is observed that such predicament may not be existing, and the matter can still be sent back to the permanent bench at Aizawl. In any case, there is a standing instruction that all matters pertaining to the respective benches should be heard in those bench. Para, be that as it may, the learned counsel for the petitioner prays for and is granted time till Friday
Lordship,
To-
Monday, Lord. Monday,
to Monday to obtain instructions. Para, list on Monday.
Okay.
Lordship.
Item 10. Alam for
6 to 11, my lord.
6 to 11.
6 to 11.
First for the petitioner, H. Das is Rishikesh Das. Where is he? Rishikesh Das. Yes,
Just I want some time, my lord. Take the file.
okay. Bring out. Yes, Mr. That matter, K.K. Mohanto, Game Mohanto. Other side has come. Yes. Mr. Datta, who is it, Mr. Datta?
Not able to find. I
Huh?
have seen, sir, in the morning. I'm not able to locate now.
Try to look at him. When
Yes.
we don't want to rise now at 11 o'clock. Mr. Sharma, which matter?
11.
Yes.
Really, a lot. Please, the lordship, may it be taken after some time. The carriage.
Yeah, I may start it, my lord. We have this matter already heard and remain for submission of final written argument.
Heard by which bench?
Already Justice Soumitra Soikia. And I have to submit the final argument.
Then we'll send it back to
No,
the
no,
bench.
yes, my lord, that can be also done. And on that day, my lord, for final disposal, my mother acquired that the matter could not be taken up
Okay,
and
okay.
remain
Okay, we'll
several times in this
Um,
parlor.
both the learned counsel for the parties have jointly submitted that this matter was substantially heard by a coordinate bench within bracket Justice S. Saikia. And it was fixed for written arguments.
We have to file a written
Written arguments. Para? In the interest of justice, let this matter.
It is
be lis-
regarding erroneous refund, my lord. That
Let this matter be listed before the appropriate bench. Hdas. Hdas-ৰটো হ'ব, বাকীটো নহ'ব। Barua, which is your matter? You have some matter?
Second installment, matter set, item 4.
Yes, Mr. Alam.
Here, my lord, actually, my first point earlier I raised, my lord, where it was ex parte order, my lord.
Now, let us start it from the beginning.
Yes, my lord. Here, my lord, what is happened, my lord? Land was purchased is actually, my lord, tenancy case, my lord, 1971. Land was purchased in the year 19, my lord. I have annexed here.
You had purchased the land.
Yes, my lord.
When?
It was purchased, my lord, in the year 1982. I have annexed here the copy of the state, my lord, sale deed also, page 34.
Registered sale deed.
It was registered, my lord.
Okay, then
Thereafter, my lord, one deed of relinquishment was also there. It was, my
why
lord,
deed of relinquishment?
because, my lord, this deed of relinquishment was in 1982, because land was actually, my lord, petition, here, my lord, with the tenant actually. We have
Who?
purchased from the tenant. The land was purchased from the tenant, my lord. Priority hotel holder, one Togoru Post was.
How can you purchase land from a tenant?
But it was in
Under the
the,
71 Act, if
Yes,
the
madam.
land vests
yes, my
with the tenant, there is a clause that you cannot sell it.
rightly or wrongly, but it was purchased, my lord. And thereafter, my lord,
You
what is-
cannot.
Right.
The only purpose of 71 Act is for the landless riots.
yes, my lord.
If you fulfill the
Yes,
condition in 71 Act,
yes, my
you
lord.
can make an application
Yes,
and land would be given to you.
yes, my lord.
Now, how that land cannot be sold?
Yes, my lord. That was, my lord, purchased in the rightly or wrongly, my lord, it was purchased. And also, my lord, it was also registered deed. The page 39, my lord. Deed of relinquishment of plot of land measuring 2 bigha 2 kata 18 lessa is covered by DAG number, Khotian number, so part number is part of alias sale deed 18/4/1973 between Maisena Laskar, wife of Omio Kumar Laskar, by religion Hindu, by profession Sanso Boragao, Ramsarani Jalukbari, and Sri Togoru Post. Togoru Post was the actual right of Khotian holder, my lord.
He had
He has,
executed the deed of relinquishment.
yes, my lord. My lord, thereafter, my lord, what is happened, my lord? One, my lord, this case, my lord, case was, variety case was, my lord, proceeded, my lord. Page 46, my lord.
Who had what case?
That was, my lord, for cancellation of, my lord, said, the actual owner, my lord, filed this title holder, my lord, filed this case, my lord. By taking, my lord,
Title holder is SPA number 6. Mr. Alam, you are the title holder.
IP11, my lord.
Huh? 5 to 11.
IP11.
Title holder.
Title holder.
Title
We have
holder.
recorded part of that, my lord.
Oh.
When we have come to know that the land has been illegally transferred, we have filed an application for cancellation of the ticket here.
but
That
it
was
was
allowed.
1982, subsequently 2010, it was filed, my lord. Case has been finally disposed of. Both the parties are absent. Page 46. The applicant Sri Saman Narayan Dev filed an application on so alleging right. He was part of attorney holder, my lord. Or Sri Togoru Kos, son of Sri Ramsto, transferred a plot of land covered by DAG number 254 patta number without taking permission from the patta holder, have to cancel the said right patta. After inquiry into same, report has been submitted to the circle officer Guwahati Revenue Circle. Statements are recorded on the applicant patta holder. Circle officer after filed inquiry, filed letter number so dated, report has been submitted. The case has been registered for cancellation of the royalty in violation of the section 9 of the Assam Temporary Settlement Act 1971. As Sri Toguru Coast without knowledge of the patta holder, permission.
Okay,
from-
that we have understood. Then what orders passed?
Thereafter, my lord, accordingly, it was, my lord, accordingly, it was cancelled, my lord, but being agreed with the said, as
Cancelled which date?
lordship,
Cancelled on which date?
that's under the said,
On which date?
Rayati Khotian also cancelled, my lord.
Date?
Yes, my lord.
29/9/10, my lord. Page 48. my lord.
20?
29/9/2010, my lord.
2010.
Righty case number 12 of the 2010.
The royalty holder, without taking permission from the government behind the back of the patta, cannot transfer his land.
Okay, then
Thereafter, what is happened, my lord? As we did not receive any notice, my lord.
for the cancellation.
Yes, my lord. No notice was served to us upon us, my lord. And my lord, one field report executed by one of the, my lord, H. Talukdar, who submitted report. Latmondal report was there, my lord, in the record, but we did not found there, my lord. That he, on the basis of this same, my lord, we submitted, my lord, application under Right to Information Act, my lord. On what basis, my lord, it was, my lord. In the page 55, documents of DAG number so notice served upon Maisona Laskar and family before as per the ADC Nareshwar Upadhyay dated so who served the notice, authority and sources of delivery of the notice, on whose name notices served and who received it, signature. Latmondal report of H. Talukdar 27/2010 and others. These are some of our queries. Ultimately, my lord, in revenue board we filed appeal, my lord, there. But in the revenue board, page 67, my lord, passed that expert order, my lord. During lockdown time, my lord, it was date of judgment 5/1/21.
67.
67, my lord. Under appeal 60, appeal under section 67 of the Assam Temporary Settle Act 1971, Maisona Laskar, wife of Chanso, Paschim Borago, district Chanso, against the order dated 20 passed by the recent date. They filed, my lord, this appeal, my lord, but their appeal, my lord, our grounds were, my lord, I want to place page 69, my lord. Our basic grounds were there, my lord, page 69. Proper notices were not served upon the appellant in the said royalty case number 12/2010. The additional deputy commissioner had no jurisdiction to pass impugn order dated so as the power of appeal and revision are vested only upon the director of land record. The additional deputy commissioner erred in ignoring the fact of long peaceful position of the appellant since the year 1973, for which the claim of the respondents was in time barred. Additional deputy commissioner erred in ignoring the fact that whether the land in question was used for agricultural purposes. ADC wrongly held that the appellant was a non-agriculturalist based on the fact that the husband of the appellant was employed under the Indian Railways. The failure to obtain permission from prior to transfer of holding only has the effect of forfeiture of the interest of the tenant under section 50 of the Assam Tenancy Act 1971, and the same would not render in favor of the appellant for it. The final royalty Khotian in the name of Toguru Coast was issued in the year 1983, by which the time the sale in favor of the appellant was already concluded, and hence if the respondents were aggrieved, they ought to have preferred an appeal under section 59 of the Assam Temporary Settled Tenancy Act 1971 before the Director of Land Records within 2 months from the order passed by the settlement officer prior to final publication of the records of right. The land in question was already included in the municipality and was classified as town land, and hence the question as to the application of the Assam Temporary Settled Act 1971 does not arise. These were the grounds, my lord.
Hmm.
My lord, respondent case, it is mentioned, my lord, and ultimately, my lord, the upheld the state order, my lord, of the cancellation order of the
Okay, appeal has been dismissed.
dismissed, my lord.
Now, what are your grounds here?
Here, my lord, my grounds, my lord, I have stated, my lord, that is, best first ground was, my lord, it was not hard. The learned counsel who was conducting the case, B. Deka was there. He could not be able to appear there due to page, my lord, 11, paragraph 12 of my petition, my lord.
Hmm.
To submit a aforesaid application before the revenue board, but not be able to assess the date and position of the case. He is not engaged. Moreover, he did not go to the case of the case number record. Another state of law, Bideka and another advocate Guwahati were engaged there in the date of filing. Even on some occasions when Bideka advocate was called by your petitioner over telephone to know the status of the case, every time he misguided your petitioner that due to pandemic situation, her case has not been proceeded in the board. Accordingly, your petitioner was under the wrong impression that her case has been stopped completely. Thereafter, your petition has been kept in dark by the said learned advocate. Resultantly, he could not be able to know about the fate of the case. However, Mr. Esdas, when he went to know about the status of the case of the petitioner in the Board of Revenue, he also apprised about the pendency of the appeal. However, Mr. Das went there and Assam Board of Revenue on 28/1/21 for seeking the response of the earlier application 9/10/2020. Then he could come to note Mr. Borua, Planet Office of the Revenue Board, that behind the back of your petitioner and their engaged counsel Bideka, that their revenue appeal has been already disposed of ex parte on 5/1/21 itself. And as it was a purchase law in India 1973, my lord. So law, my lord, is that there is judgment also, my lord. He can be able to section, my lord, that is Assam Tenancy Act, my lord. The Assam Temporarily Settled Tenancy Act 1971. Section 21, my lord, 22, 23 are important, my lord, here. Acquisition of intermediary and ownership rights.
Just a minute, 649. Yes, you are referring to the 71 Act.
Yes, 71 Act. my lord.
Yes, which provision?
My lord, the section provision 21, my lord.
21.
Yes.
Yes, please.
Acquisition of ownership right and intermediary rights by tenant.
Yes.
Here, my lord, in this notwithstanding anything to the contrary in any law, custom or agreement on an occupancy tenant personally cultivating the land of his tenant shall be entitled to acquire the rights, title, and interest of his landlord, hereinafter called the ownership rights, according to the provision of section 23(1), provided where the holding of an occupancy tenant is being cultivated by an under tenant as defined in the Assam Temporarily Settled District Tenancy Act 1935. From any date prior to the enforcement of this act, such under tenants shall be entitled to equity rights, title, and interest of the landlord, hereinafter called the intermediary rights, and also the ownership rights of the landowner of the holding according to the provision of section 23(2). Section 23, acquisition of ownership right and intermediary rights, my lord, by tenant. it is said, provided, next again, my lord, 21, provided that further that the ownership rights of any land of a landlord who is a widow of or a minor or physically or mentally disabled person or a member of the defense services shall not be liable to acquisition under the provision of this chapter. 22 is acquisition of ownership rights and intermediary rights by the government for tenants. Next one, page 20, section 23 says that acquisition of ownership rights, intermediate rights by tenant. Any occupancy tenant personally cultivating the land of his tenancy desirous to acquiring the ownership rights of his landlord may at any time make an application in writing to the deputy commissioner, and on such application being made and compensation as provided in section 25 determined and paid by the occupancy tenant, the deputy commissioner shall declare the said occupancy tenant to have acquired the ownership rights free from the encumbrances. So that means section 25 is the apportionment of compensation, and compensation part is 24. State in section 24, compensation, the total compensation payable for acquiring the ownership rights as well as intermediary rights, if any, of any holding shall be an amount equal
No,
to
those part may not be relevant.
Yes,
We
ma'am,
are
because
on the,
50 times, at any time I can be able to, my lord, deposit that amount that is there in the judgment I have placed, my lord. One, my lord, just
now do you have after the 71 Act comes into operation,
yes, my lord.
Rayat gets the ownership right?
And my lord, I have also filed one additional affidavit.
Yes.
In the additional affidavit, he was paying the, my lord, from the year it is dividend, receipt at the next year, as now, my lord. First one is, my lord, page, and that is page 81. And my lord, it from the 28 years he was in possession, my lord, is mentioned, my lord. At page 83 is the local vernacular 1974 চনৰ জানুৱাৰী জালুকবাৰী মৌজাৰ পশ্চিম বৰাগাঁও 62 নম্বৰ খতিয়ান ভাষীৰ দখল তগৰু কোচ পিতা চেনিৰাম দখল 28 বছৰ। Next page is page 84. Suren Sharma, these are the original Pattadar Mala. Suren Sharma, Ganesh Sharma, Ganesh Sharma. Toguru Kos Pita Seniram Seni Post, Dohol Sotaka Mati, Ekmon Dhan, Doholot Polo Bostor. By 30 number 14 Likito, a Maisana Lusker, wife of Omio Kumar Lusker, Ponoro Bostor. The whole carry Omio Kumar Lusker, Maisana Lusker. And copy of Timal Khazana, it is dividend from the year 1977.
Mr. Alam, which is the provision where after acquiring the occupancy right or ownership right,
He has to apply, my lord.
he cannot part away with this land.
My lord, justice judgment.
We'll come back to. We'll come. Yes. Which one? Which one?
Kind of say section 50.
1-5.
50. The respondent number 5 to 11 has availed the remedies provided under section 50 of this Act of 1971. Because, my lord, there is no dispute, my lord, that Togori was the recorded riot. But in view of illegal transfer of the same, what others have applied for cancellation of Rayati Khatiyar. That was cancelled. He cannot still.
Yes, 50 is the part.
50.
This was
50 is, my lord. And my lord, this is the submission that they were not heard. Your lordship, I cannot see the order of the London ATC. Wherein, my lord, they were given opportunity, they were heard, they had placed on record the photocopy of still deed, my lord. Your lordship, I cannot see order of the London ATC, wherein this has been reflected, my lord. Now, I'm referring to page 46, my lord, of repetition.
4-6.
46, my lord.
Yes.
Last paragraph, my lord, of this page, my lord, at bottom. Notices are served upon the Khatian holders also. After receiving their pages, Sona coach, Vasudev coach, Sona coach, Kamala coach, Vitul coach were physically present and told that on 2021 years ago, their father Toguru coach had expired. As per a statement of the sons of the riot holder, told by them that their father during period of surviving transferred the plot of land without any permission from the Pata holder and also told them they are not in possession of that plot of land. Statements statements are enclosed here at page number 22. As per report of the circle officer, it is known that the Raiti Taguru case court transferred the land in the names of Raiti, Maisana Laskar, wife of Soito, Titu Laskar, Hemanto Laskar, both are sons of Omi Laskar. Hence, notices were sent to them, who accordingly received notices of the same. After receiving the notices of the same, Maisana Laskar, Titu Laskar, on writing informed that the Guru coach by Sili was going to transfer the land to them and submitted the photocopy of hereof. It is court, my lord. It is absolutely incorrect to say that they were had not heard by the learned ADC at the time of passing this order, my lord. The recorded riot is not having transferable rights, my lord. And that too in favor of a non-agriculture. Accordingly, this order was passed, my lord. And my lord, your lordship may kind of see the order of the revenue, Assam Board of Revenue, which is improved hearing, my lord. In a very clear language, my lord, considering all position of law, Honorable Assam Board of Revenue has passed this order, my lord.
Yes, Mr. Das.
As per law, but we are entitled to, because it is the old land 1982. We have the residential house. All findings are here. But as per the law, my lord, I have placed two judgment, my lord. First time, your lordship, Peruz 2018 judgment, my lord. It was my lord Justice M. Buzar Burua, my lord. Just I am placing, reading the present term, paragraph 28, 31, 34, my lord. I have placed 2018 for GLT 533.
Which paragraph?
Paragraph 28 to 31 and 34.
Hmm.
It is stated, it is settled law that a beneficial legislation must be liberally constituted as to the fulfill the statutory purpose and not to the first state case. In the instant case, as has already concluded that Tenancy Act 1970 is a beneficial legislation for the benefit of occupancy tenants. In order to enable them to acquire the ownership right over the tenant, then it being so, the second proviso, section 21, would have to constitute in a manner.
But how do you overcome this provision of law at 50?
My lord,
Yes,
Well,
but
You
that
cannot
is also.
transfer. You cannot part away. We cannot transfer.
well, for this purpose,
But here, my lord, in this both the judgment, my lord, under section 147 also, my lord, Justice Hishikesh Roy's judgment also, my lord, it is specifically mentioned as the amount, my lord, compensation he can be able to deposit at any time to the government by writing
The
application.
question is not of compensation. The question is of transfer.
Transfer, my lord. It was transfer, but it was transfer to the
Can it
tenant.
be transferred?
Transfer to the transfer by the tenant. Right?
Can the tenants transfer?
Yes, to us, my lord, because
Can it be done?
that cannot be, but it was done in the year 1982, my lord, and sale was there, my lord. We are in occupation. We will pay the compensation, my lord, 50 times more. And there is a no bar also, my lord, for time.
There is a doctrine called caveat emptor. Do you know what is the meaning of caveat emptor? Caveat emptor means buyer beware.
Ah.
Before you buy something, you have to exercise due diligence. You cannot buy something which the vendor did not have the power to sell. He did not have the authority. There was a bar in law
Yes, my lord.
under 50.
More than, my
There was
lord,
no due diligence from your part.
45 years ago, my lord, it was passed, and they have the residential house there, rented house also. That's why we are going to submit application before the deputy commissioner and pay the all compensation also, my lord, because there is a optional clause, it is mentioned, my lord.
No, that's a
At
different,
any time, we can be able to, my lord, submit application and
No.
pay for transfer,
not you.
for ownership.
The riots,
Guru Coach was his legal heir, my
by
lord.
the
Yeah,
riots.
but instead of Toguru also, and that is why, my lord, intermediary right is there by tenant, my lord.
You are not the subtenants.
Not, yes,
Intermediary rights would
By
may accrue
subtenant.
to a subtenant.
But
You are a vendor per se, pure and simple vendor. You purchase that plot of land, may not be your fault,
yes, my lord.
but we have to go by the law.
Your lordship, I cannot see section 23, my lord. Till date, no application is there, taking ownership right by Guru Coach or his legal heir. They just don't have transferable
No,
rights. my lord.
during the pendency, how can I? We,
Okay,
there
let
is
me-
no
let
bar
me-
also, my lord. In the judgment, matter specifically mentioned, at any time we can go, beneficial is protecting the
No,
right,
no, not who. You are not Toguru. Mr. Das,
lordship.
you are not Toguru.
Yes, my lord.
Neither Toguru nor his
He
legal
has-
heirs.
He has already expired.
No, neither his
Legal
nor
heirs-
his legal heirs.
Represented before the ADC, my lord. There is space to
They,
recommend.
but they have specifically mentioned that, yes,
You are
it was
for the purchasers.
purchaser, but it was, my lord, purchased by my mother, my lord, petitioner and his son, my lord. And what has happened actually, my lord, the subsequently the owner of son of the, my lord, rightly hotel holder also admittedly, yes, it was sold. These their statements are there. Rightly or wrongly, my lord, in the year 1982, they have sold it out, and thereafter they have the residential house, my lord. They are in the land.
If something is barred by law, it is barred by law.
That is why, my lord, as I'm, my lord, submitting this
Why
judgment, my lord.
don't you negotiate? They want to buy the property.
My lord, they are very aggressive, my lord. We are not in a position to approve them, my lord. They are raising multi-story transfer building of this land.
No, only stop and residential.
Multi-story transfer building.
Mr. Das, pay them if you are having a building.
If he is ready to share a portion of the land for their residential purpose, we are ready, my lord, but they are not in a position to
No,
negotiate.
let them offer you a price, proper price. Huh?
But,
We'll leave
but
that.
except this land, we don't have any other land. So we are not in a position to leave entire land. That will be part
But
of
are you staying in that land?
my lord?
You're not staying there.
Not, we are not
Then-
staying there.
Then
Now we are staying over land within our family is not in a position to accommodate. Family members have been.
understood. But if you
So many
get some,
partners.
if you get a good
Suitable
return,
value, then there is no
suitable,
problem. my
well,
lord.
then you can.
They are not offering, madam.
That you can always do. But yes,
That is open for them, my lord.
yes. Okay. Please let me. The instant petition has been filed under Article 226 of the Constitution of India, putting to challenge an order, a judgment dated 5/1/2021, passed by the learned Assam Board of Revenue, bracket hereinafter ABR, in case number 6 RA within bracket K, bracket close /2015, by which the appeal was dismissed and the order dated 29/9/2010, passed by the learned ADC Kamrup within bracket M in Rayoti case number 12 of 2010 was affirmed. Para. As per the facts projected, the petitioner had at us purchased the subject land from one Toguru Coach by a registered sale deed. Full stop. The said Toguru Coach had also executed a deed of relinquishment. Full stop. Thereafter, the private respondents who were the recorded patadar had applied for cancellation of the Rayoti Khutian and vide the order dated 29/9/2010, passed by the learned ADC Kamrup, by the ADC Kamrup M in the aforesaid Rayoti case number 12 of 2010. The application was allowed and the Rayoti Khatian was cancelled. Full stop. It is the case of the petitioner that no notice was issued to her before such cancellation, and accordingly, an appeal was preferred in the learned ABR, which was registered as 6 RAK লিখিছিলা না /2015. Para? The learned ABR, while the impugned judgment has affirmed the order passed by the ADC, Kamrup. It is the validity and legality of the order of the learned ABR which is the subject matter of challenge. Para? I have heard Sri H. Das, learned counsel for the petitioner. I have also heard Sri S.S. Roy, learned state counsel for the official respondents, whereas Sri N. Alam has appeared for the respondent numbers 5 to
11.
11. Para. Sri Das, the learned counsel has submitted that the land in question was duly transferred via registered sale deed. Which was purchased from one Togoru coach. He has also drawn the attention of this court to the deed of relinquishment executed by the vendor. Full stop. He submits that thereafter the petitioner had made constructions over the said land, and long thereafter the application was made by the private respondents for cancellation of Rayoti Khatian. Full stop. In the said proceeding, no notice was issued and the Rayoti Khatian was cancelled, which would ultimately affect the rights of the petitioner. Full stop. He has submitted that the learned ABR had passed a judgment on 5/1/2021 ex parte as the period concerned was the period of lockdown, and there were restrictions for the learned counsel for the petitioner to appear. Full stop. He has also alleged that there was communication gap between the set of lawyers engaged by the petitioner. Full stop. Para. The learned counsel for the petitioner has drawn the attention of this court to the Assam within bracket temporary settled areas bracket close Tenancy Act 1971 and has submitted that under section 21 thereof, acquisition of ownership rights and intermediary rights by tenants have been defined. Full stop. He submits that the said provision starts with a non-obstante clause and is a beneficial piece of legislature wherein maximum benefit is to be given to the riots. Full stop. He has submitted that by the initial order dated 29/9/2010, whereby the Rayoti Khatian was cancelled, the petitioners were not duly notified of the said proceedings, as the right, in spite of the fact that her rights were involved in the said case. Full stop. The learned counsel has also placed reliance upon the following cases. One to her. In the case of Bikram Fukan, this court had dealt with the act in question and the subject matter was the transfer, was the conferment of ownership upon the riotee on fulfillment of the conditions given in the said act para. In the case of Baleshwar Rangpi Supra, this court had held that the Act of 1971 being a beneficial piece of legislature, liberal construction is required whereby maximum benefits can be given to the riots. Para. Sri Das accordingly submits, Sri Das Learned Counsel, no? Learned Counsel accordingly submits that the instant writ petition be allowed and the impugned orders be set aside. He has reiterated that the petitioner has constructed residential house
By taking permission from
by taking permission from the GMC, and immense loss would be caused to her without any fault of hers. Para. Per contra, the contesting respondents number 5 to 11, represented by Sri N. Alam, has contended that the very foundation of the case projected by the petitioner is erroneous. Full stop. He has submitted that the land in question could not have been purchased by the petitioner from the riot, namely Toguru Coach, in view of a clear bar under Section 50 of the Act. It is submitted that simply by executing a deed of relinquishment or executing a sale deed, the rights and interests cannot be transferred by a riot, as it would be against the objective of the Act. Para. Sri Alam has also refuted the contention advanced on behalf of the petitioner that the proceeding before the ADC was held without notice to the petitioner. He has highlighted the part of the order dated 29/9/2010, which records that not only notices are issued, the petitioner had submitted the sale deed, which were taken into consideration. Full stop. Para. As regards the allegation that the learned ABR had passed the impugned judgment dated 5/1/2021 without hearing the learned counsel for the petitioner, he has submitted that there were continuous default, and in any case, the decision rendered is strictly in accordance with law. Full stop. He has also submitted that the proposition of law in the two case laws relied upon by the petitioner, though not disputed, will not have any application in the present case. Para. The rival submissions have been duly considered and the materials placed before this court, including the original records, have been carefully perused. Para. The Act of 1971 was enacted to give certain benefits to the tenants, and the preamble of the act reads as follows. Preamble to 649. Full stop. Under section 21 of 21, is it 21? I think
21 is it? But we are not
No.
to refer section 8, my lord.
section
8.
A.
8.
Take with
Right of transfer. Right of transfer by recorded right.
Under section 8, comma, an occupancy tenant shall have the right of transfer in respect of his holding with prior permission of the government in the manner prescribed. Full stop. The procedure has been laid down in section 21, which is under chapter 6 of the said act. Full stop. The amount of compensation which is to be paid has been laid down in section 24. But however, there is a provision in the act in the form of section 50 regarding the forfeiture of tenancy. Full stop. For ready reference, section 50 is extracted here and below. Full stop. The aforesaid section clearly lays down that if a tenant sublets or transfers the whole or any part of the land in question, comma, the interest of the tenant shall be forfeited. Full stop. In the instant case, comma, the original tenant, namely Tagaro Coach, could not have executed any sale deed, and execution of the deed of relinquishment will have no meaning. Full stop. Though an argument may be made that the sale deed has not been put to challenge in a separate suit, comma, this court is of the view that the vendor did not have any right to transfer such interest which is barred by the act itself. Full stop. In that view of the matter, comma, the initiation, the first stage by which any right title or interest has been projected to have accrued is apparently fallacious. Para. As regards the order dated 29/9/2010 passed by the ADC Kamrup in Rayoti case number 20 of 2010 is concerned, comma, this court has observed that notice was indeed served upon the petitioner, who had also placed on record the copy of the sale deed. Full stop. Para. As regards the this court has also gone through the reasons cited by the learned by the ADC, which appears to be in sync with the objective of the act. Para. As regards the impugned judgment dated 5/1/2021 by the learned ABR, comma, though the petitioner, though the learned counsel for the petitioner would be correct in contending that the same was passed in absence of the learned counsel for the petitioner, comma, the second paragraph of the judgment itself makes it clear that several dates were given in the proceeding, which was pending since the year 2015, and a last chance was given, in spite of which there was no representation. Full stop. For ready reference, the said observation are extracted herein below. Page 68, first paragraph. Okay. Be that as it may, comma, this court has observed that the learned ABR has not only formulated the grounds of challenge, but also has dealt with each ground in accordance with law. Full stop. A writ court exercising the certiorari jurisdiction is to oversee that the jurisdiction exercised by the inferior, by the subordinate court or tribunal is within the bounds. Full stop. In the instant case, it is observed that the jurisdiction exercised by the learned board was in accordance with law, and the impugned judgment has been passed by taking into consideration all the relevant facts and circumstances. Para. As regards the case laws relied upon by the learned counsel for the petitioner, this court is of the opinion that there is no dispute to the proposition of law laid down in the said decision, which would, however, not come to the aid of the petitioner in the instant case. Full stop. Para. In view of the above, comma, this court does not find any merit in this writ petition, and accordingly, the same is dismissed. Para. It is, however, at this stage, Sri Das, learned counsel, has submitted that his client may be given liberty to negotiate with the private respondent for transfer of the land in accordance with law. Full stop. It is made clear that dismissal of this writ petition shall not be a bar for the parties to settle the matter in accordance with law.
I level it.
Much.
Records to ঘুরে যায় না? Send back the records. Yes, what is this?
Wait, please, Lord.
Yes, you will be appearing.
I'm hearing for the responding to
Who is to?
the IRD
Okay.
insurance.
Grievance is against you.
No. It's against the
I'll place
insured
the
and the
fact.
insured.
Huh?
I'll place the fact.
No, grievance is
Grievance is
against
against
you.
the,
Respondent 5.
Who is 5?
5 is the policy holder.
Is he there? Served or not?
Right?
here, sir, what has happened, Lordship? He has written a letter to the registry informing that he cannot appear, and that is the thing. He has received notice, but he cannot appear. Which is tagged as flag X.
We can appoint a legal aid counsel then.
That is it.
That will be better, I think.
Yeah.
Who is he?
Who is Mr. Day? Shankar Nath Day. Shankar Nath Day.
Okay.
Respondent,
Sri K. Heart Sri K. Mohanto and Sri Subham.
Siddhant.
Siddhant Datta. No, Heart Sri K. Mohanto, counsel for the petitioner, as well as Sri Siddhant Datta, Learned Counsel for Respondent number 2. Full stop. The Learned Counsel has, however, submitted that the principal grievance is against the respondent number 5, who has been served. Full stop. This court has, however, has noticed that the said respondent number 5 has issued a letter to the registry intimating his inability to engage a counsel. Para. In view of the above, comma, the registry may appoint a legal aid counsel for the respondent number 5.
Your Lordship, in fact, the order which has been challenged, that has been against the passed by the Ombudsman, respondent 3.
The ombudsman has been served.
But they have not
Your
monitored.
Lordship.
Okay, let this, he is
Yes.
the beneficiary of this order.
Yes.
Upon such appointment of a legal aid counsel, Sri K. Mohanta is directed to furnish copies of the relevant documents to the appointed counsel. Para. List immediately after the vacation for orders so as to fix another date of hearing.
Comply.
Simply out.
What was the matter?
Matter is premium has been increased. We are for the insurance company, Star Health. So the ombudsman has given an order saying that the increase of premium is bad. We say, after Lordship is aware, there are two types of health insurance. One is on the age. Once the petitioner is still 65, there is a separate premium. But after he attains 66 to 70, the premium gets enhanced. That is that within that area, the premium-
Ombudsman said that you cannot increase
Yeah,
the.
that.
You are agreed by
Yeah.
that. The insurance is still operating.
Yes,
Operating.
operate.
Mhm.